May it please the court. My name is Zandy, initials JM, and I appear for the defendant. To assist the court in its deliberation on this matter, there are four preliminary points that have universal application to all of these issues. First, it is conceded that the defendant's company, Super Consulting Pty Ltd, is her alter ego, and consequently, any actions taken by it can be taken as if they were the actions of the defendant personally. Second, as the defendant's employment contract contains a severance clause, voiding one of the terms will have no effect on the other terms, and consequently, for the same reason, the defendant does not need to void the whole contract in precondition of striking out terms A, B, or C. See Cedar Hills and Flower Foliage Pty Ltd versus Springburg, Queensland Reports, page 482, paragraph 35. Third, when considering restraint clauses, the court must determine if the restraint was reasonable or not on the time the contract was formed. See Linda vs Murdoch's Garage, 1950 case, Commonwealth Law Reports, page 83, paragraph 628. Fourth, it does not matter what name is given to describe the work that the defendant now seeks to perform for her new employer, nor that the work that is structured the contract as a consultant. What is relevant is to compare the factual matrix of the old employer against the new. I refer the court to the 2005 New South Wales Supreme Court case of Portal Software International Pty Ltd versus Bodworth at page 1179. I turn now to the terms in sequence of A, C, and B. Term A has no temporal or geographical restrictions. It attempts to bind the defendant for the rest of her life, wherever she may work from at any location on the planet. The term seeks to stop the defendant from divulging any information which may reduce the competitive position of the company to any person. By this clause, 40 years from now, the defendant will still be barred from sharing stories with a 10-year-old grandchild about anything she may have done whilst working at the company all those years ago. In the case of Littlewoods Organisation Limited and Harris, a 1987 appeal court case at page 241, Lord Denning, at paragraph 1479, says, "It is so difficult to draw the line between information which is confidential and information which is not, and it is very difficult to prove a breach when the information is of such a character that the servant can carry it away in his head." The second restraint in term A attempts to capture any information used for the benefit of any person. Again, information is not defined, and in this case, it's not even constrained to a requirement that it be confidential. Consequently, this clause must also fail. Term C does not apply as the factual matrix of the defendant's current employment shows that it is not an equivalent role to that of her previous employment. By the authority of Portal Software, in the event that the court finds that this term does apply to the defendant, it is void for unreasonableness because it applies a worldwide restraint. I refer the court to the authority used by the plaintiff of Smith and Nomad Modular Building, and note that they omitted to mention that the restraint was limited to Western Australia and Queensland only, at paragraph 30 of that case. I direct the court to a 1938 case of McFarlane and Daniel at page 38 of the New South Wales State Reports, paragraph 337, where it was found that if you cannot sever the unreasonable characteristics of a term, the whole term fails. Therefore, our submission is that term C of the contract be struck out as void. Term B has two parts. Part A relates to the clients and Part B relates to the staff. B is not relevant in this case. The plaintiff has alleged that the poaching of clients is directly relevant to this case. The scope of Part A has the effect of extending the restriction past that of current clients to include past clients and potential clients alike. The inclusion of a 12-month pre-termination period is simply a furphy with such an extensive restriction. May I remind the court of Smith and Nomad Modular Building. It is stated at paragraph 36 that an employer is not entitled to be protected against mere competition. Imposing a restriction that has a catchment area of past and potential clients is far beyond the reaches of reasonable. It is an attempt at protection from competition and is against public policy, and therefore Part A of Term B is void and Part B remains. In conclusion, it is submitted that it is just for the court to find terms A, BA and C are void on the grounds that they are against public policy and are not reasonable between the parties. Thank you.